Well, hello everyone, and welcome back to AJ102, Introduction to Criminal Justice. My name is Tony Farrar, and of course, I am your instructor for this semester. So this week we're going to take a look at Chapter 9, where we're going to discuss and learn a little bit about the court structure and those actors, players, or personnel that operate within the court structure. So a lot to cover. Let's go ahead and just kind of jump right into things. So we want to be able to describe the state court structure, also take a look and describe the federal court structure, and we'll see that there are some differences, right? We're going to identify problems associated with the amount of cases. And this really leads to court congestion, and are there ways to rectify this? Discuss the duties, qualifications, and selection or appointment of judges. Explain some different types of judicial alternatives. Are there other things we can do to dispo this case, if you will, instead of going to trial? We're going to identify some factors associated with decision making, take a look at the role of the prosecutor, recognize the role of discretion that the prosecutor has. We're going to take a look at the role of the defense attorney, and then explain the right to counsel, which is extremely, extremely important, okay? All right, so let's go ahead and kind of jump right in. So the criminal court is the setting in which many of the most important decisions in the criminal justice system are made. Eyewitness identification, bail, trials, plea negotiations, and sentencing, they all involve court decisions. And the criminal court system itself is a very complex social agency with many independent but interrelated systems. Administrator, prosecutor, defense attorney, judge, probation department, all of these different things are separate entities, okay, but they are they're connected as well, right? So they're interrelated subsystems. And this entire process, from filing the initial complaint to the final sentencing of a suspect or a defendant, is governed by very precise rules of law designed to ensure fairness. Now, however, in today's crowded court system, these goals are really kind of abstract, and they're really often impossible to achieve because the nation's court system is chronically underfunded, and recent economic downturns really haven't helped this as well, okay? So there's a lot of things going on in the court systems, things that affect people but also affect, companies and courts and different things like that. So, with that being said, these constraints have a significant impact on the way courts carry out justice. Okay, quite often the U.S. court system is the scene of accommodation and kind of working things out, rather than the arena for a vigorous criminal defense, right? So a lot of times the court systems are more apt to, let's make a deal, let's work things out, than, really working within that adversarial court system process where you have the prosecutor against the defense and all the facts come out and the jury decides. It's easier and quicker, right, to go ahead and just kind of make a deal. So that's something that kind of comes out of this. Now, plea discussions are far more, they're much more common than a formal trial. Okay, so I mean, there's just a lot of, and keep in mind that over 90% of cases that fall, they're dispositioned, or they're disposed, if you will, via plea bargain. Okay, and maybe even more, but you're pretty on target with kind of a 90%. Now, with all of this kind of said, consequently, the U.S. criminal justice system can be somewhat selective. Discretion accompanies defendants through every step of the process, determining what will happen to them and how their cases will be resolved. And discretion, as we're going to talk more about, means that, two people committing similar crimes may receive very different treatment, right? And that's really not how it's supposed to work. Most people convicted of homicide, for example, receive a prison sentence, but about 5% receive probation as a sole sentence. And indeed, more murderers get probation than the death penalty. So a lot for us to cover. So in this chapter, again, we're going to take a look at the structure and the function of the court system. And we're going to take a look at how it's basically evolved over the years into a kind of a intricately balanced legal process. And while not everybody thinks, the process is totally fair, if you've been to other countries, it really is better than almost any other place in the world as far as procedure and structure. It's not perfect, but it is a very robust system. So let's talk a little bit about it. So to house this complex process, each state maintains its own state court organization and structure. There are 50 state trial and appellate systems with separate courts for the District of Columbia, Puerto Rico, and other U.S. territories. Now, usually 3 or more separate court systems exist within each state jurisdiction. And states are free to create as many courts as they wish and to name the courts kind of like what they want to. So example, felony courts are considered superior courts. Okay, so there's some flexibility built into the number of courts and what we might call them. So there's a lot of diversity in court organization from state to state. Not every state is exactly the same. And in the bottom left here, there's a video that you can listen to. It's about 7 or 8 minutes long, and it talks specifically about how the state court system works, and it's actually a really cool video, so I would recommend that you watch it. Okay, so, again, each state maintains its own state court organization and structure. And, common courts, state courts, are going to include the following. So we're going to look at some common courts, right? And depending upon the jurisdiction in which they're located, you'll see some of these or more of these, but let's talk about them individually. So we have first the courts of limited jurisdiction. And this is a court that has jurisdiction over misdemeanors, but it also conducts what we call preliminary investigations on felony charges. So they don't do, they do the prelims, if you will, but they don't actually, they're not the trial courts for felonies. Then you have specialized courts. And this is a court that has primary jurisdiction over specific types of offenses and that operates differently than a traditional criminal court, such as with a concern over outcomes and extensive judicial monitoring. So that's kind of a specialized court, okay? And that could be something like, dealing with estate issues or divorce or something similar like that. They could focus on treatment and care for special need offenders, or even sometimes family or juvenile court, okay? So that could fall into that specialized court area. And then we have what we call courts of general jurisdiction. And this is a state or a federal court that has jurisdiction over felony offenses, serious crimes that carry a penalty of incarceration in a state or federal prison for 1 year or more. And there are approximately 2,000 courts of general jurisdiction that exist in the United States. And again, because they name them differently, here's a couple of different names that they might go by. It could be a felony court. It could be superior court. It could be Supreme Court, county court, and even circuit court. It just kind of depends what they name it. But these are all different names, if you will, okay? And these particular courts handle the more serious felony cases, things like murder, rape, robbery, etc. Okay, they might even handle some civil cases where the damages are extremely high. And courts of general jurisdiction may also be responsible for reviewing cases on appeal from courts of limited jurisdiction, so those misdemeanor courts, right? So again, these are all kind of defined, so we're looking at each one of these individually. And then the other kind of common state court would be what we call the appellate court. And this is a court to which appeals are made on points of law resulting from the judgment of a lower court. And the appellate court may be asked to evaluate the impact of new evidence, but more typically, it decides whether the state or federal constitution was improperly interpreted during that case. So what you can kind of start to see now as we go through each one of these courts is kind of a hierarchy, kind of a pecking order, if you will. There's a lower court and then there's a higher court. And in a minute, we'll look at kind of a little chart that shows you how this really does work. And here's the chart. So you can see that we're talking about, some specialty courts that we talked about. So we have municipal courts, domestic relations court, drug court, gun court. We have a county court, superior court, intermediate appellate courts, and a state Supreme Court. Okay, and typically, and again, it might vary just a little bit in different states, but these are typically this is kind of a model, if you will, that shows the different courts and how they work. Okay, and just again keep in mind that sometimes they name them different. For law enforcement, you can kind of look right here. This is typically where you're going to end up maybe testifying. So this is the highest trial court with general jurisdiction. But again, just kind of a little thing to show you. Okay. Now let's talk a little bit about federal courts. So those are state courts, right? So we talked about the different state courts, and just, if we were to go back and kind of rehash them just really quick, we would start again with the lowest. Remember, I talked about kind of a pecking order. Okay, so we would have that court of, limited jurisdiction, okay, over misdemeanors, but they would do some preliminary investigations on felony charges. Then you would have specialized court, and this is a court that has primary jurisdiction over specific types of offenses, and it operates a little bit differently, right? Than a regular trial court. Then you have the court of general jurisdiction, and this is a state or a federal court that has jurisdiction over those kind of higher up felony cases, if you will. And then you have the appellate court, and this is the court to which appeals are made on points of law, etc. So you can kind of see how there's this pecking order as it starts to move up within the state. Now, when we start talking about federal courts, the legal basis for the federal court system is contained in Article 3, Section 1 of the U.S. Constitution, which basically provides that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So when you look at the federal court system, you can see that, and it probably would have been better to turn it around, but the lowest level of federal courts are the district courts, okay? And you can see the number of courts. And then you have the Court of Appeal, okay? And again, we're talking about the federal side, and I have this video where you can watch it as well. And then you have the U.S. Supreme Court. It's called the Court of Last Resort because this is the highest court in the land. Once your case gets here, if it gets there, because they don't have to accept every case, and we'll talk about that, there is no other court. This is the highest court. So, and remember, don't confuse it. States have a state Supreme Court, but the federal, the U.S. Supreme Court is the highest court in the land. So just kind of keep that in mind. And there's also a little chart that you can kind of look at as well, where you can see there's, at the bottom here, there's some specialty courts even on the federal side. So there's military courts and veterans appeals, there's tax courts, etc. Then you have the trial courts, which are the district courts. Okay. Then you have the appellate courts, the Court of Appeals. Okay, and that's next, and this is the federal side. And then you have the United States Supreme Court, and that's at the very top. So just to kind of touch on them just a little bit more, so we give you a little bit more deal, or a little more detail. So within this authority, the federal government has established, again, this three-tiered hierarchy that we kind of went over of court jurisdiction that kind of in order of ascendancy consists of the district court, the Court of Appeal or circuit courts, okay, and the U.S. Supreme Court. So that's the hierarchy. So let's talk now just briefly about district courts. So these are the trial courts for the federal system. And federal district courts were organized by Congress in the Judicial Act of 1798, and there are currently 94 courts in operation. And if you want to see a video on the district court system, you can go here. And the district courts have jurisdiction over civil rights cases, interstate transportation of stolen vehicles, kidnappings, citizenship rights of immigration, illegal aliens, etc. Okay, so that's kind of the district court, and the jurisdiction for the U.S. District Court will occasionally overlap that of a state court. So just kind of know how that happens, though. But that's some basic information for you to know. Now, next would be the court, or the Federal Appeals Court. And there are 13 U.S. Court of Appeals, sometimes referred to as circuit courts. So I know there's a lot of different names, right? So it kind of gets confusing a little bit. But you guys will get the hang of it. And the name is derived from the historical practice of having judges basically ride the circuit, if you will, and regularly hear cases in the judicial sets of their various jurisdictions. So they would actually kind of move around from place to place. So again, the U.S. Court of Appeals is the appellate court in that federal court system. But kind of an interesting thing, why they call it the circuit court, is because they were basically, they were on the circuit. So kind of a thing. And the circuit court is empowered to review federal and state appellate court cases on both substantive and procedural issues involving rights guaranteed by the Constitution. And keep in mind that circuit courts neither retry cases nor determine whether the facts brought out during the trial support conviction or dismissal. Instead, what they do is they analyze judicial interpretation of the law, such as the charge or instructions to the jury, and reflect on the constitutional issues involved in each case. So they don't retry it. They look at those things that kind of took place, right? So, yeah, I've got a little bit ahead of myself, but here's kind of what we're talking about. And again, there's a video that you can watch. But again, they analyze, judicial interpretation of the law, and that's their job. It's not to retry the entire case. So make sure that you kind of understand that. And if you look at the circuit courts, here's a map of the circuit courts, and you can see where they're located. Okay, and you can see this would be the Western Circuit Court over here for us. Okay, and then finally, and we have a lot more to talk about, but now we're at the U.S. Supreme Court, right? And the U.S. Supreme Court is the nation's highest appellate body, and its nickname kind of is the court of last resort for all cases tried in the federal and state courts, because there is no higher court. That is it, okay? So that, hopefully that kind of makes sense. Now, the Supreme Court is composed of 9 members, basically appointed for lifetime terms by the president with the approval of Congress. And the Supreme Court, the U.S. Supreme Court, has discretion over most cases it will consider, and may choose to hear only those it deems important, appropriate, and worthy of attention. Now, sometimes the numbers vary a little bit, but the court basically hears about 300 or so, if you will, of about the 5,000, sometimes 7,000, depending upon what number you hear, but we'll go with 5, of the 5,000 cases each year. And that's, really not a lot, right? And kind of consider that the Supreme Court is a little bit unique, right, in several ways. First, it is the only court established by constitutional mandate instead of federal legislation. Second, it decides basic social and political issues of grave consequence and importance to the nation. And then finally, the judges basically shape the future meaning of the U.S. Constitution. Their decisions identify the rights and liberties of citizens throughout the United States. So, they have a big job ahead of them, because this is the court that interprets the Constitution. No other court does that. This court does. So, when the Supreme Court rules on a case, the ruling becomes what we call precedent, commonly referred to also as what we call kind of a landmark decision, if you will, which must be honored or followed by all lower courts, right? And all the other courts are lower, so you can see how that works. Their rule, whatever they rule is kind of, everybody has to go by it. And this use of what we call precedent, and I put the word case in there because typically it's a case, right? The Supreme Court accepts a case, and we'll tell you how you get a case to the U.S. Supreme Court in a few minutes. But it's a case that makes precedent. So this use of case precedent in the legal system gives the Supreme Court power to influence and mold the everyday operating procedures of the police, the courts, corrections, etc. And there's a term that comes out of this as well, and it's called stare decisis. And it basically means let the decision stand. And that's kind of the precedent foundation, if you will, for the U.S. Supreme Court. So again, talking about how the Supreme Court is unique. Remember, it's the only court established by the Constitution. It decides important political and social issues, and it shapes the future meaning of the Constitution. And when the Supreme Court rules on a case, it's by majority vote. So there are 9 on the Supreme Court, so 5-4, right? And if you want to learn more about the Supreme Court, I have a little video right here. And they're also in your Canvas, your class Canvas as well, okay? So that's a little bit more on the Supreme Court. So how now does your case get to the Supreme Court? So most cases that come before the Supreme Court, again, involve this significant federal question, usually of a constitutional nature, okay? And when the U.S. Supreme Court decides to hear a case, it grants what we call a writ of certiorari, okay? Some people say certiorari. It depends how, potato, potato, right? Tomato, tomato. Okay, enough of those. But it's a writ of certiorari requesting a transcript of the proceedings of that particular case that's doing the petition, that writ, for review. So a writ of certiorari is an order of a superior court requesting that a record of a lower court be brought forward for review. Okay, so you have the U.S. Supreme Court, the highest court in the land, so they're asking a lower court to send us the stuff. We think we want to hear this case, and then they review it, and then they decide whether or not they're going to go ahead and hear the case, etc. So again, for a writ to be granted, ordinarily 4 of the justices must agree to hear the case. This is kind of known as what they call the rule of 4. So if just one justice wants to hear it because they think it's interesting, that's not enough. You need 4 that agree to hear the case. Not in rendering the decision, okay? If we go back here, when the Supreme Court rules on a case, it's majority 5-4. The rule of 4 means we have 4 and now we have enough to hear the case. And in reaching a decision, the Supreme Court basically reevaluates and reinterprets state statutes, the U.S. Constitution, and previous case decisions. And then based on all of that review of that particular case, the court either affirms, upholds, or reverses or overturns the decision of a lower court. And hopefully that kind of makes sense a little bit. And then you have the justices that actually write some information on how that is. So when the justices, again, when they reach a decision, the Chief Justice of the court will assign someone of the majority group to write the opinion, and another justice will normally write the dissenting or the minority opinion. And when all of this is finished, it's submitted to, it's basically published and submitted to the public, and then it becomes what we call, again, the law of the land. So, I mean, it might seem a little confusing at first, but you can obviously see the pecking order and the complexity, right, of the entire process. Okay, and here's a little kind of chart that talks about tracing the course of a case to the U.S. Supreme Court. And it kind of shows you how this case works its way up to the U.S. Supreme Court. Okay, so one of the things that I hope you recall at the very, very beginning when we were talking was we discussed a little bit about court congestion. Now, the vast U.S. court system really has been overloaded by millions of cases that are brought each year. And state court systems now handle about 100 million new cases annually. That's per year, which really has led to significant delay and congestion. And here's kind of a percentage, if you will, that show how some of these cases typically break down. Civil cases are around 18%. Domestic relations type cases are 6%. Criminal cases are 21%. Juvenile cases 1.4%. And traffic cases about 54%. Now, although they are fewer in number, federal courts are equally burdened with approximately 80,000 criminal cases that are filed in the district courts each year. And the U.S. Court of Appeals, decide approximately 55,000 criminal appeals each year. So it's really crowded, right? And there's just a lot of congestion. And congestion really is undesirable for, quite a few reasons. Congestion is time-consuming, costly, and it can delay and basically threaten the Sixth Amendment, right? The right to a speedy trial. So, what are some reasons perhaps for congestion. Why does it even happen? Well, it could be, increasing populations. There are some, states are basically kind of outgrowing the court systems, if you will. It could be aggressive prosecutions. So as the law becomes more complex and involves, such technological issues as, intellectual property rights concerning computer programs and all these other different things, the need for more involved court proceedings kind of, comes up. And some communities have attempted to control crime by aggressively prosecuting petty offenses, right? Complex law, kind of the computer stuff I said. Reform efforts. Ironically, efforts being made to reform the criminal law may also be leading to, kind of this court overload. The increase of mandatory prison sentences for some crimes may reduce the use of plea bargaining and increase the number of jury trials because defendants fear that a conviction will lead to incarceration. So even some of the reforms that have been looked at might actually make this a little worse. And then civil litigation, which really is a big one because this is increased as people have, come to view, basically kind of look at or view the court process as a means of basically redressing all kinds of personal wrongs. And this can result in a lot of what we call frivolous lawsuits, meaning lawsuits really with no basis or no merit, if you will. So, and just there are so many lawsuits that are filed that really do have no merit. Now, we need the system, but we don't need it to be overloaded. And there are so many frivolous lawsuits, it really does tie up the court system. So that kind of runs us through the system a little bit. Now let's start to take a look at some of the individuals that operate within the system. Now that we kind of have a little bit of, an idea. So let's look at judges. So let's talk about the judiciary. So the judge is the senior officer in a court of law and is authorized to basically, decide cases. And a judge's duties are varied and far more extensive than might be expected. Now, before we go further, it's important that you know these two things. The judge is what they call the trier of law. So they're going to deal with the law. Who's an expert? What kind of evidence can be admitted into court? Whether or not to allow a statement in. The law, right? And the procedure. The jury, on the other hand, is the trier of fact, meaning that they decide the outcome. And it's pretty broad because the jury can believe basically whoever they want to believe. Okay, so just know that the judge is the trier of law. The jury is the trier of the facts, because the court case, both the defense and the prosecution, their job is to bring out the facts. That's why you have a court trial, and that's why it's adversarial, right? One person wants to win, but both sides bring out facts. And then the jury weighs the facts, and then they decide. So that's why they are the trier of fact, if you will. Now, the judge also has extensive control and influence over other agencies of the court. Probation, the court clerk, court reporters, public defender, district attorney's office, meaning the prosecutor, and also law enforcement. Okay, so a lot of things that they do have influence or control over. So with that being said, then, what are some of the duties of the judge, or what does the judge rule on? Okay, well, again, the judge rules on the appropriateness of conduct, settles questions of evidence and procedure, guides the questioning of witnesses, whether they accept an objection by an attorney or they overrule an objection, etc. Instructs the jurors at the end of the case. In some cases, decides the case. There's not always a jury trial. There could be a bench trial, which is just with the judge. And the judge will also determine sentencing. Okay, so these are some of the things that the judge basically rules on. Now, with all of that, what are the qualifications to become a judge? Well, the qualifications for appointment to one of the existing 30,000 judgeships, if you will, vary from state to state and from court to court, probably like you expected. And typically, though, a judge must reside in that state, be licensed to practice law, be a member of the State Bar Association, be at least 25 years of age and less than 70 years of age. And, some municipal or town court judges do not need law degrees. So sometimes some of the smaller judgeships, if you will, in some little locations, they really don't have to have a law degree. So that's kind of an interesting thing, though, right? So the way that they're selected, there are many methods that are used to select judges. In some jurisdictions, the governor appoints the judges. And in other states, a judicial nominating commission is formed that submits names. And in other states, it's by popular election. And, elections are typically less common in higher level courts. Okay, which is why when you talk about something like the U.S. Supreme Court, the judge is appointed by the president. Okay, so as they kind of get higher, the higher level courts, there's typically going to be more of an appointment than there is an election. But about 90% of trial judges face elections. And judicial selection, again, can be through what they call appointment. And the process could be where the governor selects a candidate who is confirmed by the state senate or other official body. It could be by election, which is where a potential judge runs as a partisan or nonpartisan politician during a regular election cycle. Or it could be what they call the Missouri Plan. And this is where a bar committee searches for qualified candidates, and the governor chooses among them, and then the judge runs for reappointment in a nonpartisan election. So kind of interesting, right? Just a lot of different things when it comes to selecting judges and what have you. All right, so we kind of talked about the Missouri Plan, so we can go a little bit further. We'll just go a little bit further, and we'll take our first break. So now we're going to talk about judicial alternatives. And we know that increased judicial caseloads have really prompted the use of alternatives, okay, to a traditional judge, if you will. For example, to expedite matters in a civil case, it's become common for both parties to agree to hire a retired judge or a different or another neutral party and abide by that person's decision. So that's kind of an interesting one. Other jurisdictions have created what they, kind of new quasi-judicial officers, such as referees or magistrates, to relieve the traditional judge of time-consuming responsibilities. And some other jurisdictions use part-time judges. And many of these are attorneys who carry out their duties, basically what they call pro bono, for no or limited compensation. And basically these judicial adjuncts or part-timers assist the courts on a temporary basis while maintaining an active law practice, okay? So they're kind of helping out the system, if you will. So these are some judicial alternatives. So not having to waste the time for the judge. All right, so now we're going to talk a little bit, we're going to, a couple of other alternatives, right? So we'll give you some definitions, and then we'll probably take our first break. So here's a couple of other definitions that you really need to know, because there are some other judicial alternatives. So the first would be, alternative dispute resolution. And this is a judicial alternative. And it's defined as a means of settling disputes outside of the courtroom. And typically it's done by, one process would be what they call arbitration. And this is a process of dispute resolution where a neutral third party, they call that person an arbitrator, renders a decision following a hearing at which both parties agreed to be heard. And typically arbitration is binding, meaning that whatever the arbitrator says goes. And then there's something called mediation. And this is an informal dispute resolution process in which a neutral third party, a mediator, helps the parties that are having the dispute reach an agreement. And mediation usually it comes before arbitration, and it is non-binding. So basically the mediation is they get together, there's a dispute resolution process, everybody's there, they try to work it out, and the mediator will come to a decision, but it's not binding. So if they can't settle the case, then they move forward to what they call an arbitration. And that's where there's a neutral third party, that arbitrator, but typically that person's decision is going to be binding. So again, these are judicial alternatives instead of using a judge. Okay, now we're going to talk a little bit quickly about judicial decision making. Well, you know what? We're right about the 40-minute mark or so, so I think this might be a good spot for us to take a break. We'll take our first break, and then we'll come back for part 2.